Final case of this morning's call is People versus Anthony McFarlane. This is a mini oral argument on the application. Each side has 15 minutes. Call that case.
May it please the court, my name is Mike Villar. I'm here on behalf of Mr. McFarlane. This court issued an order back on October 17th of 2019 it directed us to file a supplemental brief regarding whether the prosecution's medical expert invaded the province of the jury by using the phrases abusive head trauma and definite pediatric physical abuse to label her diagnosis, and if so, whether my client's rights under People versus Crean were violated. In other words, did we satisfy the plain error standard under Crean's in order to justify overturning his conviction? So I did file and submitted a brief on that. I would point out that in this case, the Court of Appeals actually, I think I put that in my application for leave to appeal, did most of the heavy lifting on the issue of whether the expert invaded the province of the jury by labeling the diagnosis as abusive head trauma, definite pediatric abuse, characterizing it as child abuse. Mr. McFarlane was convicted of a shaken baby syndrome case, which is now termed abusive head trauma. And so the testimony of the expert indicated it was definite pediatric abuse. Even the Court of Appeals indicated that the use of the language by the expert indicated that not only did it invade the province of the jury in terms of what happened, that it was abuse, that it implied that he had a willful intent and the requisite negligence or recklessness to create the mens rea that's required for the conviction. So I think in the Court of Appeals, the Court of Appeals actually analyzed it in a sense that said, yes, what the prosecutor's expert did was invade the province of the jury. So the real issue in the case is whether the standard in Crean's has been met for my client. And I think that I noticed that in the Prosecutors Association's brief, they said this is a new rule that the Court of Appeals is trying to start with dictum, and I don't think that's true at all. I think that cases that deal with experts testifying as to the credibility of witnesses or bolstering the credibility of witnesses go back to People versus Roe over 100 years ago. And it's been a constant thing with our court is that an expert can't just testify that they believe a victim or a witness in a case. So I think in here, the issue of People versus Crean's, whether the plain error had an impact on this, I think the Court of Appeals did a couple of things that was wrong in their analysis. First, in their sufficiency of the evidence review, they note that we have to make inferences, every inference in favor of the prosecution. That even if that leads to multiple inferences or inferences upon inferences, even if Katie's testimony was not entirely clear, we have to take the version that's most favorable to the prosecutor. We have to assume that everything, even though there's expert witness testimony on both sides, we have to take their side of the expert testimony, and because all of that in a sufficiency of the evidence review, it has to be in favor of the prosecutor. So then what happens is they conflate the two standards. So under Crean's, when they did their analysis under Crean's, they said the totality of the evidence was strong. And so what I found when I read the actual transcript was not only was the totality of the evidence not strong, it was actually quite weak. If I cited the transcript where the one witness, there was one eyewitness that testified, was a 5-year-old. She was 7.5 when she testified. And her testimony, she didn't know which state she was in. She didn't know which state she lived in. She couldn't remember whether she called Anthony dad, stepdad, or Anthony. But here, more importantly than those things, she said, and I'm citing page 2 of my brief, and this would be volume 2, page 108 and 109 of the transcript. I don't know if he meant to choke, but he did. Can you explain that to me? I'm not sure if he really meant to do it, but I was just 5, so I kind of don't know what choking really meant, so I'm not so sure. Well, can I ask you what choking means? What does that mean to you? What happened? No verbal response. Do you understand my question? No. Then later, she said that she was peeked over a corner, and she said, and when you peeked, what were you looking into? The living room where she was at. Did you see whether or not Anthony was still in the living room? Yes, he was. When you peeked in the living room, what was Anthony doing? He was shaking her. Did you hear him say anything to her, to Katie? No. I said no. So you didn't hear him say anything. Could you describe how he was holding her when he shook her? Well, like you hold a little baby. Well, can you tell me how that was? What did you see? I can't remember now. It just remember like a baby. That's all I know. Then the prosecutor tried to elicit more. Okay, when you hold a baby, you could hold somebody. I'm showing you your legs, by your waist, your belly, your shoulders, your armpits, something else. Was there any part that you can remember how he was holding her? Like he was holding her? I can't remember now. So I was actually shocked when I went through the transcript because I had read the Court of Appeals saying that the totality of evidence was really strong. And when I looked at the actual witness testimony, it wasn't strong at all. In fact, it was riddled with her saying, I don't know. And then her saying he was holding her like a baby is, in my estimation, not something that would necessarily incur violence. And then you have Dr. Brown, who was the expert witness for the prosecutor, saying that this diagnosis of definite abusive head trauma required a violent shaking. And so what you have here is, it's unlike the Thorpe and Harbison case. Because in Thorpe and Harbison, I think the issue was you can't have an expert testify as to probable pediatric sexual abuse if there's no physical evidence that was seen by the person who examined the person, the victim, the alleged victim. Here, we don't have that same situation. We don't have the fact that there was a medical exam for physical sexual abuse, but we do have this shaken baby syndrome evidence. Now, I think this court has already looked at, in People versus Ackley, you've looked at the shaken baby syndrome, and it's kind of under attack. It's being questioned at this point. And I think the court even said in Beckley, that kind of testimony about shaken baby syndrome or diagnosis is used more for talking to other physicians as opposed to being a reliable indicator of whether abuse occurred. And I think that's what we have here. We have this doctor testifying that it was definite pediatric child abuse, definite abusive head trauma. And what that served to do in this case, just like in Harbison, it served to have the expert witness bolster the credibility of the only eyewitness to the shaking that there was. And I think that's what makes it improper, and that's what makes it violative of Kareen's. And I think in this case, the Court of Appeals, it's interesting, when the Court of Appeals talked about the analysis under Kareen's, it did not say the full Kareen's, it says, however, plain error will not warrant relief unless the defendant demonstrates that the error affected the outcome of the lower court proceedings. Well, that is not the test that Kareen's sets forth. It's a plain error standard that says error occurred, the error was plain and clearly obvious, the plain error affected the substantial rights of the defendant. So reversal is warranted when there's a conviction of an actually innocent defendant, but then there's an or when an error seriously affected the fairness, integrity, or public reputation of judicial proceedings independent of the defendant's innocence. So the Court of Appeals did two things wrong. They used the sufficiency of the evidence standard to justify that they said that the evidence was strong when it shouldn't be a sufficiency of the evidence standard. And then they did not do a full and complete analysis of Kareen. So not only did they use the wrong evidentiary standard, they actually didn't fully review all of what Kareen's required. So I think in this case, Mr. McFarlane did suffer from plain error. The error was obvious. I do think it affected substantial rights because once you look at the testimony of the victim in this case, how many times she said she didn't know, how she could not describe what the shaking was. She said it was like he was holding a baby. I don't remember. So that was the expert served to bolster her testimony and her credibility, saying, well, if the expert says that it could only be happened, this abusive head trauma can only be happened by violent shaking or throwing someone down, the expert did two things. One, the expert was bolstering the credibility of the witness, the only eyewitness in the case. The second thing that the expert was doing was actually telling the jury that she believed this was definite abusive head trauma, that it was child abuse, and that the defendant in this case had the requisite mens rea to be convicted because he was either intentionally shaking her
Well,
violently.
she didn't say anything about the defendant being the perpetrator here. She just testified as an expert should properly testify as to the medical condition that was suffered by the victim. I don't
mean Dr.
understand why
Brown?
this is like Harbison.
I'm
I
sorry.
say I don't understand why this is anything like Harbison.
Well, because she crossed over into the ultimate issue of the case, saying this was definite abusive head trauma. Just the terminology itself suggests that you're invading the province of the jury. The Court of Appeals acknowledged that as well. They said this is language that should not be used. This language was clear error to use because it does invade the province of the jury.
I understand the rhetorical problem that you're referring to. It's a pretty awkward or unwieldy definition for a medical syndrome to refer to a term that also has some legal implications. But it is, apparently it is a medical condition that's been labeled as such by the American Academy of Pediatrics. How do we try to tell the doctor, you know, you can say anything you want to in testifying as an expert, but don't identify the condition that you've identified the victim as suffering?
Well, I think if the medical establishment decides to use it, I think that even the term shaken baby syndrome has some problems invading the province of the jury, because what you're doing, and I think in the CDAM brief, they've raised this issue too. When you are implying that it was non-accidental and humanly caused, that does bolster the testimony of any kind of eyewitness. The doctor is able to say that this couldn't have been an accident. This had to be something that was physically inflicted by another human
Don't we
being.
allow that, though, in homicide cases?
In
And
homicide
the word
cases,
homicide is used as the cause of death.
yes, and we do that in homicide cases. They have the added benefit in a homicide case of actually doing an autopsy and actually examining the body and a cause of death, whereas in a shaken baby syndrome, it's different, because here there's no outward physical evidence of any injury. Just like in Harbison, there was no outward physical evidence. They look at subdural hematomas, they look at retinal damage and retinal hemorrhaging. In this case, I think there's another important point, is that this victim was, at birth, suffered a stroke in utero, and the left hemisphere of the child's brain was only 1/3 its normal size. So it wasn't raised in the Court of Appeals, it wasn't raised in any of the lower courts, but I raised this on the appeal to you, is that why wasn't there a Daubert hearing demanded? Because first of all, shaken baby syndrome has been in decline.
Counsel, there was other evidence, though. I mean, was this testimony alone basically enough to kind of trigger the outcome?
In terms of what testimony, Judge?
The physician's testimony, is that enough to, I mean, ultimately, is that enough for the jury to hang its hat to basically ultimately say that, you know, any concerns they might have as to reasonable doubt could be assuaged?
Well, I think so. I think that the prosecutor, the CDAM brief, again, addressed the very issue. When it's a closely contested case,
Yeah.
the testimony of an expert becomes even more important, because that expert's testimony gives the jury a hanger upon which to place their hat.
Right.
In other words, in a particularly heinous crime, that expert testimony says we don't want somebody who's charged with this heinous crime to walk away. So if an expert says it, then we are going to believe it.
I see.
And in a closely contested case, I think it's more important, because in this case, there were experts that testified to the contrary, but the jury still believed the one expert, even though there was no real eyewitness testimony to the crime. And even though there was no Daubert challenge to the fact that does shaken baby syndrome even apply to a child whose left hemisphere is only 1/3 its normal size. And so that went unchallenged, as far as I know. I think that experts testified about that, but there should have been, in my opinion, a Daubert challenge saying, how can you even apply shaken baby syndrome or abusive head trauma to that actual physical case? Because I'm fairly confident there are no studies on what happens to, can a shaken baby who has a brain 1/3 of his normal size, does it more easily show subdural hematomas? Does it more easily show retinal hemorrhaging? That was an issue that hasn't been raised. I think it's an effective assistance of counsel claim, because I think that should have been raised. And I think in this case it's particularly important because the victim was, I think even when you look at the expert witness testimony and the differential diagnosis that they talk about in using shaken baby syndrome, one of the things they have to exclude is a disease process that might have caused the actual injuries. And in this case, we did have a disease process. We had in utero strokes. We had a brain that was 1/3 its normal size, and that just seemed to escape everyone's attention. So I think in this case, even the differential diagnosis of shaken baby syndrome should be called into question, because there was a disease process with this child that could very well have caused shaken baby syndrome attributes on the child, which really weren't a result of being violently shaken, but were rather a result of having a deformed or a defective brain.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. Meredith Beidler, Assistant Prosecutor for the County of Allegan, on behalf of the people of the state of Michigan. The Court asked the parties to address two specific phrases that were used by prosecution expert Dr. Sarah Brown during the trial in this case, which are definite pediatric abuse and abusive head trauma. I'd like to start with talking about definite pediatric abuse. This term was used by Dr. Brown. She was on the stand for quite an extensive period of time, and that phrase was only used by her 4 times. Then in her closing, the prosecutor didn't dwell on Dr. Brown's diagnosis that this was definite pediatric abuse. In fact, she only addressed that statement 1 time. Now, she did argue it was child abuse. That was the preface of our case. But she did only reference Dr. Brown's statement that it was definite pediatric abuse 1 time. Instead, she painted this whole picture of the events leading up to the shaking, the events leading up to the hospital stay, and the eyewitness account that actually saw the shaking happen. And then in closing with the defense attorney, he acknowledged that his experts had said this is not pediatric abuse. In fact, one of the doctors testified during his testimony 5 times that this was either not pediatric abuse or there was not enough evidence to prove pediatric abuse. In fact, the jury heard more often that this was not child abuse than this was child abuse. Regarding abusive head trauma, the American Professional Society on the Abuse of Children's amicus brief addresses this diagnosis very well, I believe. It was the medically accepted term at the time this trial took place. But 2 defense experts, Dr. Smith and Dr. Mack, both got on the stand and testified that this diagnosis wasn't necessarily even valid, or that it should be diagnosed at all. Dr. Mack went so far as to say that Dr. Brown couldn't diagnose abusive head trauma. She could claim that there was suspected child abuse, but she drew the line there. I'd also like to discuss the difference of this case between Harbison and Thorpe, because there's been a little bit of discussion about that. This is vastly different from Thorpe, the facts in that case where the expert was asked to opine on how many children lie about pediatric sexual abuse, and it was something like 2 to 4%. In that case, you could see how he's vouching for the credibility of the child witness. And then in Harbison, the doctor, she physically examined the child, like Dr. Brown did in this case as well, but her conclusion wasn't based on any physical evidence that she found that the child was sexually abused. It was based on the child's statement that she was sexually abused. Now in this case, Dr. Brown wasn't asked to opine on the credibility or veracity of any witnesses. The baby that was shaken was too young to say what happened. The child that witnessed the shaking didn't even discuss this with Dr. Brown. Dr. Brown didn't even know that there was maybe an allegation of shaking because that was never discussed. Now, simply because Dr. Brown's testimony stated that it was abusive head trauma and that kind of corroborates the sister's testimony, it doesn't necessarily mean that it served to bolster. Just because it happens to lend itself to be the same thing. They're 2 different areas of distinct evidence where one's an eyewitness account and one's a medical expert that's not even based on that eyewitness account.
But counsel, what do you think about that notion that it gives the jury, if they have any questions or concerns, if it's a close call, it gives the jury, I like to use that expression that was in the briefs, the ability to hang its hat on something, the ability to say, well, if the doctor said it, if the expert said it, they must be right, and they seem to be pretty affirmative in terms of their belief. Do you feel that does have an impact in terms of the outcome of this case?
Well, I think that would be the case if, as in like Ackley, that case where the defense didn't present any experts to rebut that testimony, but in this case, there were 3 separate experts that defense presented that stated this either wasn't pediatric abuse, there was no signs of trauma, or that abusive head trauma wasn't a valid diagnosis.
So it's your perspective that it's the battle of the experts, that if you have a litany of experts on each side, that can help to merit this. But you don't believe that there could be a concern that could arise with the fact that juries are looking for something. If they're just not sure, if it's a close situation, that this type of testimony could, even with the advent of other experts, you don't feel that it just gives them that opportunity to say, you know what, this doctor feels strongly about it, and that's enough for me.
But you could also argue the adverse of that, that these other 3 doctors feel strongly that there was no
Okay,
abuse or
I
no trauma.
Okay.
And also combined with the eyewitness testimony, I think all of that garnered together leads to this conclusion.
I see.
If there are no other questions.
Thank you very much, counsel.
you.
Your time was expired as well, so the case will be submitted. It is 12:20. 1 o'clock. We'll be back at 1 o'clock.
Thank you.
Thank you.